We have some things that are unanswered because I don't have those documents from immigration to really say. And so I think that lawyers are really in between a rock and a hard place, and so are their clients. So there's a regulation. Okay, there's a regulation, and actually, this will be fun. My new book came out, The TV's the Framework. I have it all post-it noted because I'm always looking for more typos in a book I just published or something else that I want to change later on. Anyway, I published this book to try to give lawyers an overview of T visa cases, some great ideas for screening, just some strategies and things like that lawyers can work on. And one of the things that I'm addressing in the book is like, why should you file a T visa case? And also some of the risks that people might face, like this scare that people have related to bona fide determinations or being placed into removal. And so I'm going to talk a little bit about the T visa regulation that came out in 2024. I'm going to pull it up here. I think I probably have it memorized at this point. But basically, the regulation says that USCIS generally will not place somebody into removal proceedings, even like while they have a T visa pending, or if a T visa case is denied, unless the person has an egregious criminal history or they're a terrorist or a trafficker. So if you're not a terrorist or a trafficker and don't have a egregious, super serious criminal history, then denying a bona fide determination work permit should not result in a referral to removal proceedings. So here it is. Referral, this is straight from the regulation. Reading from my book where I quote the USCIS regulation. Referral of applicants for removal proceedings. USCIS generally will not refer an applicant for T non-immigrant status for removal proceedings while the application is pending or following the denial of the application. Absent, so like unless there are serious aggravating circumstances such as the existence of an egregious criminal history, a threat to national security, like being a terrorist, or where the applicant is complicit in committing an act of trafficking. So unless it's an egregious criminal history, you're a terrorist, or I suppose a spy would also be a threat to national security, or where the applicant is complicit as like an actual trafficker themselves, you shouldn't have a bona fide determination denial resulting in a notice to appear for removal proceedings. But all this to say, and I know I talk a lot and I always have long answers, but all this to say, just because under the Biden administration, there was never this notice to appear for removal over a denied T visa case, nor over a denied bona fide determination, because we used to get some under Biden as well. Just because that didn't happen under Biden, and now we're in this new situation where it shouldn't happen under the new regulation that came out in 2024, and now we're in 2026, it doesn't mean that something bad won't happen, right? So we've seen in the news, ICE has arrested American citizens and even deported some of them erroneously, right? And so there were lawsuits about them doing wrong things. And we have seen a case where a person didn't have any significant criminal history, like really no history to speak of other than some traffic tickets. And yet, when immigration decided that case wasn't bona fide, they went through a full T visa decision. They decided to send a notice putting that person into removal proceedings. So why would they do that if generally they won't do it if the person doesn't have this serious criminal history? I don't know. I think they made a mistake.